Hey, this is Robert Guest with Guest and Gray. We're going to talk to you about some recent developments in criminal law. Recently, the governor issued an executive order which reduces the availability of bonds, especially personal bonds, for anyone convicted or charged with what they're calling a violent offense. In particular, there are some rules that have been suspended that you should know about. One of them is, in the past, under something called 17.151, if your case wasn't filed or the state wasn't ready to proceed, a defendant would be eligible for a PR bond or a personal recognizance bond or a lowered bond amount they could make if the state wasn't ready after 15, 30, or 90 days, depending on the offense. Now, what the governor's done is said, well, this is going to be suspended for violent offenses, and so if the state is never ready, you're never entitled to make bail. Now, the weird thing about that, and where I think they're going to have problems with all of these executive orders with criminal law, is the Texas Constitution doesn't really allow the executive branch to suspend laws. That's Article 1, Section 28 of the Texas Constitution says only the legislative branch can suspend any laws, and so you're going to expect a lot of challenges from these. Also, you have other constitutional rights to bail in Texas, and so I'm not sure if this is going to hold up. There are other ways to try to get bonds lowered and try to get people released. I think this is not a good move. We need to get people out of the jails when we can, and there's people in there who haven't been convicted of anything, or they haven't had any kind of evidentiary hearing. They haven't had any right to challenge their case. They're just being held, and jails are not safe places right now. And so if you have someone who's stuck in jail and they need help, or they're being affected by these new rules, call us right now, 972-564-4644, or visit us at guestandgray.com.